Hello everyone, welcome to Court with Krissy. If you learn anything at all from this court hearing, I hope that it's if your friend has a P number, don't ask them to help you with your court case, okay? I think you'll figure out why I said that. I hope you like it. Court with Krissy is now in session.
When we began just a little while ago, Ms. Schubert is directly examining Ms. Goodrich, so we need to conclude that. So Ms. Goodrich, can you raise your right hand, please? You swear affirm the testimony about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. All right, so Ms. Schubert, if you want to continue, please.
Yes, thank you, Your Honor. So just to get back into things, were there any supplies left at the home after Mr. Stallworth left? Silkworth, I'm sorry.
It's all right. The only supplies that were left was a gallon of trim paint, which was always in the upstairs bathroom. And then I had some wall paint left in my portion in a closet for the homeowner left. That was it.
So, but he didn't leave the bathroom paint. That was your paint for your portion?
Nope, there was a different trim paint for the upstairs bathroom, and that was for some reason left in the upstairs bathroom. That was the only can.
And that was the trim paint that was painted the wrong color?
Yes, ma'am.
Okay, but I'm wondering, how did you repaint everything if he took the supplies with him?
Well, I had to purchase tape, caulk. I did have the paint there, like I said just a moment ago, left over, but I had to buy all the other things. But those to me are business expenses. I always have them in my work van as a professional painter.
Okay, so did you have the things with you that you could use?
Yes, ma'am.
And then you had to purchase replacements later?
Yes, ma'am.
Okay, but there was paint left in the master bedroom, which you did.
And that was it. Yes, ma'am.
And that's what you used to fix the other part, repaint things.
Yes,
okay.
They were all the same color. Yes, ma'am.
Okay, I just wanted to make that clear.
Okay.
On June 12th, was that I'm just trying to be really succinct because I feel like this has been covered. To confirm that June 12th was the date that Mr. Silkworth left.
And I was told everything was done to completion. Yes, ma'am.
Okay. And did you have a phone call with him?
I did.
Okay. I didn't get these exhibits until just now. But I wanted to bring up an exhibit that plaintiff offered. Yeah, number 19. So I'll share my screen. Can you see this text on the top right corner? Sorry.
Kind of. Oh, there we go. Yeah.
Okay. Oh, sorry. Yeah. And then, all right. And did you send that to him?
Yes, ma'am.
Why did you tell him to not worry about the touch-ups?
Because after I was hung up on by Mr. Silkworth, I called the homeowner, Miss Vicki Daniels, and we had a discussion, and she said she did not want him in her home. She didn't want things to be damaged further, and she wanted me to do things and fix everything myself.
Did you feel comfortable with Mr. Silkworth after that conversation?
No, ma'am. I'm actually very scared of him. That is my honest answer.
Okay. So this text, you didn't really mean it literally?
What do you mean by that?
Like, did you literally mean, I'm happy to make it right, don't worry about the touch-ups?
That's me just trying to be polite like I have been the entire time, to have him just treat me with the same respect. It never happened. So yes.
Okay. And then I'm gonna stop sharing that. And then And just to recap again, do you recall where you were when you received your first payment?
Where I was,
Yeah.
I do not recall. I believe it might have been at the job site. It was I think the first day we had received that down payment check, perhaps. I think it was there. If not, we had met somewhere, maybe the paint store. I'm not sure.
Okay, but you don't recall. Do you recall, but you recall the amount?
Yes, ma'am.
And do you recall like the denominations of the bill?
Yes, ma'am. It was $1,200 and they were $100 bills.
Okay. Do you recall anything else specific about that interaction?
Other than he said, here's your down payment, which is half up front, which is what he gave me. That's all I recall, really.
Okay. Just a moment. All right, that's all I have for my witness.
All right, then, cross-exam, Mr. Prestering.
Thank you, Your Honor. Ms. Goodrich, how much money have you received from Vicki Daniels?
How much money have I received from whom? I couldn't hear you.
Vicki Daniels.
I have received, well, John got the first $4,000 payment. I don't know what's the balance, Michelle. I don't know, 40.
Okay.
No, you can't talk to your attorney. I'm asking you how much money has Vicki
Right,
Daniels?
I'm trying to do the math for you, sir. Sorry about that. I don't know whatever the remaining balance was. Her original bid was 8,300. I think it was the original one here. So that minus 4,000.
She's paid you $4,000 so far?
Well, the original was 7,150, and we were given a down payment, or Mr. Silkworth was, of $4,000. I don't actually, I don't know honestly that remaining balance, whatever that is.
So I don't understand. Can you please be more clear? How much did you get from Ms. Daniels? If you have to do the math, you have to do the math.
Thank you, Your Honor.
Need
I
to know.
just don't know. Let me look really quick here. Oh, 3,150. Excuse me, Your Honor. 3,150.
How do you know it's
Okay.
3,150?
Because that is the original 7,150 minus 4,000, which
She
was
didn't pay. I'm sorry, go ahead. She
what you're
didn't
asking
pay
me
any.
why I came up with that price, because that's the price. It's the original amount minus what Mr. Silkworth was already paid. Then I did all of the work to finish it, and I was paid the remaining balance.
When did she pay you?
It didn't end up getting. She had to do two payments. I know that. One was like a $2,000 check up front, and the other one I had to wait to cash. I don't even know. Must be July.
You're testifying that she gave you a $2,000 check?
Yes, sir.
When was that?
It was either the end of June or the beginning of July. Because she was having to make payments.
And then she paid you how much after that and when?
That was it, sir.
Okay, so $2,000 is less than 3,150.
Like stated, sir, the first check was for 2,000 and the other was for the remaining balance, which she asked for me to not cash till later on due to expenses of selling her home. So the total was 3,150.
So I'm still unclear, but are you testifying that she gave you a $2,000 check as the first payment you ever received from her?
Yes, sir.
And she gave that check to you in June or July?
I believe it was June, and then the other check she asked to have me wait to cash till July.
What, did she give you two checks at the same time?
Yes, sir.
How much was the other check for?
Like stated, $1,150.
Did you deposit those directly into your accounts?
Yes, sir.
When did you deposit those?
Well, the first one was the beginning one. I think it was in June. And then I believe the second one was like 2 weeks later that she asked for me to wait. So maybe the beginning of July. I'm happy to waste time looking through my receipts if you need me to.
Please.
Okay.
Okay, we found him.
Okay.
Sorry about that, Your Honor.
Well, I think Mr. Prestering asked to see those. Is that right, Mr. Prestering?
Yeah, if she can just testify to those, that'd be fine, Your Honor.
All right, okay.
So, Ms. Goodrich, when did you cash the first $2,000 check?
It looks like, what did I say? July 11th?
And you're looking at your bank records to give you that date?
I was, sir, yes.
And then the second check, can you verify the amount and the date you cashed it?
It was actually for $1,181 and it was on August 3rd. So that's what I've gotten paid.
She has not paid you anything else?
No, sir.
Has she given you anything else for painting besides the money?
No, sir.
How many hours did you spend total on the job?
On my portion, sir, or on the repairs and fixing?
Your portion and then afterwards.
Okay, my portion, I believe I was there probably maybe 5 or 6 days, and that would have been in May of 2023. Yep.
Okay, can you give me how many hours that would be?
What did I do? 5 days or so? So that's 40 hours or maybe 48 hours.
And then how much did you do after your portion?
I believe in my counterclaim, I have already written that. I believe it was 40. Was it 40 hours? No.
Can't ask your attorney.
Just a second. 48 hours at $50 an hour.
Why do you say $50 per hour?
Because, sir, I own my own company and that is my base lowest amount that I work for.
Did you charge Vicky $50 an hour?
Yes, sir.
How did you calculate the 7150?
Oh, with Mr. Silkworth, we went room by room and did this estimate together. So we agreed upon those prices.
So if the amount of hours you expected would be 7150 divided by $50 per hour?
I don't know how John has come up with his bid, but that's how I did it for my portion. Yes, sir.
You did it
Which
together.
equals one.
I couldn't hear you. I'm sorry, sir.
I was just going to say it's 143. Anyway. Sorry, go ahead, Mr. President.
How did
I'm a little confused because I thought this was like you submitted Exhibit 10 that has the bid, and it's like there's a price per room. Like there aren't any time things in there.
Not at all. No.
Or I mean,
I don't understand what opposing counsel is
I
doing.
don't,
Objection.
I don't either. Could you be more clear, Ms. Schubert?
like so Exhibit 10 is the contract that that plaintiff submitted, and it has like all the rooms broken out. So it's like it's not per hour. It's like $650 for the garage, $800 for the downstairs bath, things like that. So the mitigation piece, would be hourly, but like the original bid wasn't based on that. So I don't know why we're talking about.
You're testifying now by saying that, Ms. Schubert. You're going to have your client on redirect clear that up. The other thing is, hang on, please. My Exhibit 10 in my notes is something to do with painting the bathroom door. Several coats on the bathroom door by Mr. Silkworth.
Wait, what?
So, Mr. Prestring, what was Exhibit 10? Maybe I took it down wrong.
Here. Um,
Your Honor, Exhibit 1 is
Oh.
what Ms. Schubert just referenced.
oh, sorry,
Oh,
it
okay.
was number 10.
No,
My bad.
no wonder. No wonder I was confused.
I'm sorry.
Okay, I think Mr. Prestring is still cross-examining Ms. um, Goodrich. So go ahead, Mr. Prestring.
Thank you, Your Honor. Ms. Goodrich, you just testified that you charged $50 per hour, correct?
Yes, sir, but I do agree with my attorney. That is not how this bid, which Mr. Silkworth submitted as our bid, this is the bid, I guess. It's not broken down hourly, and these are times and money that he agreed to. So I don't know why you're asking me what I charge per hour, because my portion was for the master bedroom, and I did $22.50 based on the time it would take me. I'm not sure how Mr. Silkworth came up with his prices, but that's what he agreed to.
Okay, I'm asking you because you testified that you bill at $50 per hour. Why
Yes.
are you telling me that?
I couldn't hear what you said.
You testified that you did 48 hours for John, approximately, for his work at $50 per hour. Why did you say at $50 per hour?
Like stated, that is the minimum that I work for, and that is a price I was submitting to your honor and the court to prove the time I spent fixing all mistakes.
Okay. So you normally bill at $50 an hour, or is it a flat fee?
Depends on the job. $50 an hour is my minimum for working, yes, but sometimes it's differently bid on time, material, difficulty. Every single job is different. Yes, sir.
Okay, so John did most of this job, correct?
Not correct.
Okay. If you look at Exhibit 1 and it indicates all the rooms that he was to do and all the rooms that you were to do, what's the percentage that he was to do of the total job?
Okay, I misunderstood your question. He was supposed to have done probably 3/4 of it, but I ended up having to redo everything. So I don't know how to answer that question.
Do you know how many hours that he did put in?
I have no idea because I wasn't told the truth from the beginning of this process. So I don't know. I was on a big job as stated in all of my paperwork, an entire interior exterior, and I was working on this job on the weekends on my free time.
Okay, so if you estimate at 48 hours that you put in the job, if we round that to 50 and that was 25% of the job, then would you agree that John probably put in about 200 hours?
I do not agree, nor do I have any way to answer how many hours he put in. So please don't ask me that. I don't know.
Do you have any proof that he did not put in 200 hours?
I do have pictures I just submitted, I believe, this morning to you, showing on June 8th the progress of Mr. Silkworth's work after 3 weeks. I could submit that and show that as a screensaver. Yes.
Other than pictures, do you have any evidence that John did not put in 200 hours?
I guess I would say pictures and videos are proof of that. I don't know how, there's no ring camera, there's no way to prove. I don't know when he was there.
So hang on. So pictures or videos, those to me don't indicate hours. All right, they're just pictures and videos. So I guess your answer is you don't have any way to determine whether Mr. Silkworth put in 200 hours, right?
Yes, Your Honor.
Okay, there we go. All right, Mr. President.
Thank you, Your Honor. Ms. Goodrich, did the contract with John, well, let me back up. Did you ever sign a contract with Vicki Daniels?
Yes, I have a contract with Vicki Daniels, which, Your Honor, is why I wanted her to be my witness as the homeowner that paid for this project to be done. I do not have a contract with Mr. Silkworth. We have a piece of paper with numbers written on.
And that's all you've got with Mr. Silkworth?
That's all I have with Mr. Silkworth, yes.
Okay, so you don't have any document that says that he's supposed to caulk anything, is that correct?
Sir, caulking and filling nail holes and not getting paint all over the trim and painting the right color trim are all included in painting. He agreed to these prices for that price of the room. That is all I have to say about that. It is normal professional painting.
I'm not sure that was answering the question. I think Ms. Prestrink asked if you had any documents reflecting that he was to repair the nail holes and the other thing he asked you about.
Okay.
So
Then yes, Your Honor, I do not have a document saying that,
Okay.
although there is no document saying that it was not supposed to be done. So it kind of, why would it not be done, I guess is my question.
I don't know, just please, this is cross-exam. Mr. Prastrink has to ask the questions. Please don't, in your answer, ask a question, just please answer, okay? All right.
Your Honor, I believe I am answering.
Go ahead, Mr. Prastrink.
Thank you, Your Honor. Ms. Goodrich, do you have any document that describes the wall repair that Mr. Silkworth was supposed to have done?
I'm sorry, I couldn't hear the beginning of that. I don't know if
Do you have any documentation that indicates what kind of wall repair and the extent of the wall repair that John Silkworth was supposed to have done?
No.
Do you have any document that shows whether he's supposed to be spackling or using drywall mud?
No.
Were there any standards of any kind of painting included in any document that you have?
No.
Thank you. No further questions, Your Honor.
Okay, very good. So let's see, redirect then, Ms. Schubert.
Just to clarify the pricing structure, was the original bid Exhibit 1 broken out by hourly rates?
No, ma'am.
So would it have mattered how long it took to paint, say, the right bedroom?
I mean, it did matter because it was on a time restraint, but other than that, it's not written on this piece of paper, no.
So if it took like 200 hours instead of 20, he doesn't get more money for that?
No, ma'am.
Okay. And then you mentioned 48 hours at $50 an hour.
Mm-hmm.
Was that what you spent painting the bedroom, or was that what you spent fixing the messes?
That's what I spent fixing all mistakes correctly.
Okay. All right, that's all I have. Thank you.
Okay, any cross-exam based on that then, Mr. Prestrink?
No, Your Honor.
Okay. Okay, so any other witnesses then, Ms. Schubert?
Could I call John Silkworth?
Sure, go ahead. Mr. Silkworth, I have to swear you in. Can you raise your right hand, please? Do you swear or affirm the testimony you're about to give in this proceeding to be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, very good. All right, Ms. Schubert.
Thank you. So, do you recall submitting some photos in the small claim?
Yes, I do.
Okay. Your Honor, do you have that small manila envelope of photos?
Yes, I do.
Okay. So, it's called, like on the back of it, it's called number 18. And I only have a picture of me taking a picture of it because we never received copies. I had to go down to the clerk's office and look at them.
Wait, hang on, please. I'm confused again. So on the back of what is the number 18? Because I don't see any number 18 on the back of the manila envelope, please.
Oh, no, in the photos, I think there's maybe like, there's probably over 100 photos in there.
So are you asking me to find exhibit 18
I mean, I don't know, I guess I could just share the
or
picture
photo
of
18?
the picture.
Okay, so I've been able to find that, so I do have
Okay.
that.
Can you see this, Mr. Silkworth?
I can.
Okay. And can you tell us about the lower portion of this?
Yes, I can. I can tell you that that's what I came up with my first estimate from, or my first price of materials, but there were more materials. So I changed that. There was actually a change because of that number originally, but it appears that there's been a little bit of, the numbers weren't added up quite correctly. And first time that was my fault. I think because there were more materials that I did not include, but also that's it.
Okay. Do you recall in October when you amended your complaint, do you recall how much you listed for materials?
I have to object. Opposing counsel and I have agreed on a number for materials.
Oh, okay.
And that's fine. I mean, we can put that on the record now.
Sure.
Sure. Go ahead, Mr. President.
Yeah, we've agreed on $1,257.77 as the total amount of materials.
Okay. Very good. I'll
Yep,
accept that stipulation. Go ahead.
Okay. Yeah, and then this is just to, this line of questioning is intended to show like inconsistencies and misdirection. So on your first amended complaint, do you recall listing the total materials as 1,549.68?
Your Honor, I got to object on relevance here.
Yeah.
The reason for settlement is that we don't have to do that.
No, this is to
So-
show that he's constantly moving the football. First it was 1,300, then it was 1,500, and then the total receipts were 1,400, but they weren't even all for that. So now we're down to 1,200.
But as to these specific materials, there's been a stipulation by the parties that it's 1257.77.
Mhm.
I don't see the relevance in any further questions about that.
I offer it for purposes of impeachment.
I think it's improper to ask opposing counsel to agree to a number and then use that to impeach his client.
I mean, we've got like 3 different goalposts before we even get to the 1,200.
But there's an agreement to 1257.77.
And that's fine, but he's lied about it up until like I provided that because I went through everything that I was provided an hour before the first hearing, but that was okay. I had plenty of time to look over it apparently, but like I'm the only one that's actually gone through the receipts and added them up. And he said it's been like 3 different numbers, but it's actually a 4th.
But he's agreed on it. It seems to me that issue is resolved, but I might be wrong. So
Okay, I mean,
Mr.
the amount is resolved, but I would say he's lied, is what I'm trying to prove.
Your Honor, this is protected under Michigan Rule of Evidence 408. I mean, we've agreed on a number as part of settlement negotiations. You cannot then use that number you agree on and then use it for impeachment purposes.
No, this is the 3 times before that. We didn't, I mean, these are just from his pleadings and his exhibits. There is nothing, no settlement part of the first 3 numbers of materials that he provided this court. And we've got like the correct number, I guess, as good as we can get at this point that we've stipulated to, but up until this point, he's lied about the materials.
Well, don't say that, please. Please. That the credibility is for the court to decide.
Okay, he has misstated the amounts.
Well, what do you want to ask him then, Ms. Schubert?
Well, I asked it. I asked like if he recalls, I just want to, you know what, you can just take judicial notice of the pleadings and it's all in there. I don't have to ask him about it.
Okay. I'll do that. Okay, go ahead, please.
Okay. The next one, Okay. This one is, right. I believe this one, Your Honor, is number 39 on your,
Okay. Okay, I have 38. Don't see 39. Not seeing 39.
is it maybe towards the top of the pile? Because they weren't in order, and the ones that I took pictures of, I tried to put towards the top to make it easier for you to find.
So they appear to be in numerical order, going through the 30s up to 37, 38. I don't have a 39. I don't, because the photo after photo 38, it says F on the back of it, and then all the photos after that, there's G, for instance, I. So I'm sorry, I just don't see 39. So can you put it up on the screen?
I think I am.
All right. Okay, go ahead.
Mr. Silkworth, do you see this text?
I'm not. Oh,
I'm sorry, what?
I wasn't on the right screen. I don't think I see the text that you're. I believe I have the right text up in front of me now. I'm
Okay.
sorry, Johnny. Is that the one you're talking about? Monday,
The one-
June 19th, where your pointer is?
Like this Monday, June 19th?
Yeah.
Okay. You recall sending this text message to Hannah?
Yes.
What time did you send this?
Well,
Looks like
I
7:15
sent it
p.m.
at 7:15 p.m. indicated next to the photo.
Okay. And it looks like you're asking for $3,468.88.
Your Honor, I'm going to object on the grounds of Michigan Rule of Evidence 408. If he's making a settlement offer, that cannot be admitted as evidence.
It's not protected
Well-
under 408. It's just text.
It's just text.
Yeah, and just to flesh out my argument here, I mean, the reason that rule exists is so that parties can try to settle cases. If they're always worried about someone seeing a text message, then they're not going to make settlement offers. And that flies in the face of the reason for the rule. Moreover, there's no exception for text message
Okay.
and a napkin.
Do you recall on your Your Honor, I withdraw the question in the exhibit.
Okay, I'm sustaining the objection. Go ahead, please.
Do you recall on your first complaint where you stated you were owed $3,468.88?
I don't recall the exact amount.
Your Honor, can we also, just to save some time, take judicial notice of the pleadings in which he's asking for different amounts with several amended complaints?
I made some mistakes on the math. Oh, sorry.
Well, I don't know how the plaintiff's counsel feels about that. I mean, the testimony really, that's the evidence. I don't know, Mr. Prastering.
I do object on the grounds of relevance. I mean, if it's in the file, it's in the file. The court already knows that it's there, but it doesn't impact the hearings that we've had. And that, I mean, it often happens that litigants hire counsel who file amended pleadings. That's what we did.
All right. So I agree. So I'll sustain the objection. So please continue, Ms. Schubert.
Do you often carry $2,250 in cash with you?
When I need it.
And how often is that?
I haven't carried that much cash around with me enough times to determine how often that is. It's pretty rare, I can tell you that. I generally don't carry cash in my pocket. I keep credit cards because
Do you recall when Vicki Daniels gave you the first check for $4,000?
I never met Vicki Daniels. The check was given to me by Hannah Goodrich.
Do you recall when Hannah Goodrich gave you the check from Vicki Daniels for $4,000?
I do.
And what did you do with it?
I cashed it.
On the same day?
I couldn't tell you. I probably cashed it at my nearest convenience, so because the first thing I do is I cash a check. I pay for my materials. I put them on my card, then I pay them immediately, so I don't carry a balance and pay a percentage rate charge or whatever.
Did you pay for your materials did you charge that or did you pay cash for them?
I charged it. I charged all the materials on my Chase Inc. business card.
Okay. And so when you say you cashed the check, do you mean you deposited it or you cashed it?
Well, I don't know the proper nomenclature, but I put the check. I took the check to the bank to get money so I could pay for Hannah, and then the rest stayed in my bank because I transfer money from one account to pay my card. So at that time, I suspect, I don't know exactly, but I assume what I did was I put I put the money in there and then I paid Miss Goodrich cash. I also keep cash on hand too. So I can't be certain that's how I did that.
Could you check that if you deposited the full amount or if you
Can't check that. I no longer belong to that bank. It was Community First. It would take more than just looking on my phone because I don't have an app anymore to that. I'd have to go in there directly and ask them.
So you have no way to prove how much of that you deposited?
No, I do. I could go to the First Community Bank here in Traverse City and I could ask them. But I've closed my account there since I did this job, and I'm now with Chase entirely.
So you don't recall if you deposited the whole thing or how much you took out?
Yes, ma'am, that is correct. I do not recall. It's been over a year.
Okay. In your opinion, if someone approached you as a professional painter, would you agree that caulking and sanding and taping, not taping, but sanding, scraping, patching, cleaning, caulking, taping, cutting, are all of those pretty standard for a professional painter?
Well, I'm very glad you asked that because this particular job in the bathroom didn't have any caulk up against the several areas in the bathroom, and I didn't know if they wanted them to be recaulked. But yeah, I would say sanding stuff is common, caulking is common, but it's on it depends on the exact project.
Okay, thank you.
You don't caulk brand new wood to drywall. If you have a stained wood, there is no caulk. You don't caulk that, period.
Okay. Did you ask anybody about these questions that you had? You didn't know if it was like whether they wanted things caulked?
I didn't have the opportunity. I talked to Mrs. Goodrich 3 days before that Monday, and she told me that the homeowner didn't want to meet me and did not want to do a walkthrough with me, which I found to be very strange. So that would have been the time I would have discussed whether things were to be caulked or not caulked.
Was that over text?
No, that was over a phone call with Mrs. Goodrich.
Okay.
But what is in text is, well, you have it there.
Just a moment.
Okay.
Yeah, I do have one more question. When you and Ms. Goodrich went through and put together the bid exhibit 1 that we looked at,
Yes,
did you have the opportunity to go through every room?
that's your question. Say when we
Yeah,
did,
did you go through every room?
I went through every room that I bid, but I
Okay.
didn't go through other rooms that I did not bid.
And so you had an opportunity to see the conditions.
Yeah, I think there were 9 different projects I was doing. So yeah, I saw the conditions of those projects.
So you said 9 different projects. Like, are you counting like each room as a project?
I'm counting it just like it's broke down on the estimate, ma'am.
Okay, I wasn't sure if you were talking about like other jobs or were focused on, okay. And so you came up with these numbers of what you thought it would take and what would be fair.
Actually, those numbers, quite honestly, Hannah explained to me this was a friend of hers. It was early season.
No, but did you get to come up with these numbers?
I thought I was in the middle of answering the question. I said that her and
Was
I,
it like yes or no? Did you come up with these numbers?
it's
Okay,
not
I
a
guess-
yes or no question because I did not come up with those answers.
Okay, then that's a no.
I'm with Mrs. Goodrich, and they were
So
also,
hang on. So hang on, Mr. Silkworth.
Sorry.
So all Ms. Schubert was asking you is whether you came up with the numbers. So that would be a yes or no question. If she has further questions about the details of those numbers, then she would ask that and you could answer. Okay. So it sounds like. So what is your answer to the question? I think you got cut off by Ms. Schubert, but did you come up with those numbers? I think that was the question, Mr. Silkworth.
Okay, maybe you can help me out, Judge. I just want to make sure I'm answering clearly. I did not come up with those numbers by myself, but I did come up with those in conjunction with Mrs. Goodrich.
Okay.
Okay. But this is what you agreed.
Yes, those
you
are the
paid
numbers
for.
I agreed to.
Okay. Did it matter at all how long it took you, or was it just by the room?
It was by the room.
Okay.
There was no deadline on this job, if that's what you're asking me.
No, that's not what I was asking, but thanks. All right, I have no further questions.
Okay. Cross-examine, Mr. Prestering.
Briefly, Your Honor. John, Ms. Goodrich testified that you had told her that everything is done. Did you ever tell her that?
I did not.
Did you expect to come back?
I did indeed.
What did you want to do when you came back?
Make sure the homeowner was happy. Do a walkthrough, make sure that it was up to her standards. Usually at this point in time in the job, they walk through and say, "Oh, that's great," or "Hey, could you do something about this?" or "Hey, thanks for doing that." You know.
You expected to do a walkthrough with her?
I expected to do a walkthrough the job when I was done. Miss Goodrich already told me that the homeowner didn't want to do a walkthrough, and they, like I said before, which I think is very weird because she's paying me. But so yes, I told her that I wanted to do a walkthrough with her and make sure everything was great. And that's when she said in the text message that Miss Daniels and her decided everything was good, or whatever that text said. I'm not going to try and repeat it exactly, but the text where she said I didn't have to come back, not to worry about touch up.
Okay, thank you. No further questions, Your Honor.
Okay, anything else, Ms. Schubert of Mr. Silkworth?
Yes, so That text that we're talking about, the don't worry about touch-ups, that was June 12th, and you were done with the job then, right?
No, I had touch-up to do yet.
But there were no supplies left. Were you just gonna bring them all back?
That's incorrect. I left all kinds of supplies in the garage on a nice piece of paper, like I generally do.
And that's despite 2 witnesses testifying otherwise?
In
Okay.
fact, it is.
Your Honor, may I, let's see, this, back to, this exhibit that we were looking at just earlier. Do you see like this upper right-hand picture? Do you see that?
I'm trying to see it right now.
Okay.
The picture on the right-hand side. It's a little blurry, but go ahead.
Yeah, so let me zoom it in a bit. Is that easier to see?
Hold on. Okay, there we go.
Okay, so after this text about the touch-ups, do you recall defendant texting you, asking you where the extra supplies are?
We spoke on the phone after this, and I took a can of paint right over to her house because I was in the neighborhood. And the rest of it I explained to her was in the back or in the garage on a piece of paper, laid out neatly and clean. All the garbage was taken care of and the materials were left.
So you called her right away after this, you said?
I'm telling you that there was a phone conversation after this, in between some of this.
Because it looks like she asked you where the extra supplies were, and the next one is she also needs the spray paint, and then there's
Okay, so when she said she needed the spray paint, that's when I delivered it to her house within 15 minutes.
Okay, and then a question mark, and then followed by, I'll need to know at least what type and color exactly if you don't respond. So you're saying that you did respond and tell her where the supplies are?
You know, I don't know. I'd have to see the rest of these text messages to see where we were at in the chain of text, and I don't have that in front of me, so I can't tell you exactly. But I can tell you after she expressed to me she needed the spray paint, that's something I do know for certain. And within 15 minutes, I had it to her. I explained to her where all the materials were. I wasn't trying to hide anything. I was trying to get paid and make her happy. That's how, you know, upsetting somebody's not going to help you get paid.
I do have all of the text messages. Let me bring up, and I shared this with Mr. Prosterink. Let's see. Okay. Yeah, so, oh my gosh. Oh, here we go. Can you see this? I'm trying to make it just one screen. Can you see this on the screen?
Yep.
Okay, and so then there's a question mark, and then she needs to know what color. And then it keeps going. So, okay, and it looks like here you're dropping off the exact same kind of paint.
Yes.
So that wasn't quite right away.
She told me about the paint. I remember, I mean, it was over a year ago, but I'm pretty certain it was within a very short period of time because I was having dinner at what used to be Maddie's Okies Tavern, which is within 2 miles of her house, 3 miles of her house. And when me and my family were done, I took it over there directly.
Okay. So back to these messages. So we just looked at this one. Do you recall Hannah saying that like she'll fix all the mistakes, but she'll be deducting the hours from what your portion was?
That's not how it works, but I don't know if I remember.
That was the question. I mean, that wasn't the
I
question.
don't remember her saying that.
Okay. And then,
And I can assure you, if she did say that, I would have had something to say to it.
okay. And then it looks like down here, this was also on the 12th. I guess, no, what day was that? I think it was the 12th. Let's go back up. Yeah, so the 12th. So all of this was on the 12th. And it doesn't mention where the supplies are. And then here, do you recall this last message?
Which one are you referring to?
Oh, this is the second part of it. Can you explain where you asked if, so this message ended on the 12th, and then this is on the 17th. And so do you recall when you asked if you could come back and fix everything before you began demanding payment?
No, I was clearly told that Miss Daniels did not want me returning to her house by Mrs. Goodrich. So I had no expectation of returning after that. I mean, I do touch up at all my house. I would have gladly gone back to do the touch up and get paid the remainder I was owed. But it didn't work out.
Okay, I have no further questions, Your Honor.
Okay. Let's see, cross-exam, Mr. Prestring?
No, Your Honor.
Okay. All right, any further witnesses then, Ms. Schubert?
No, Your Honor.
Any rebuttal witnesses, Mr. Prestring?
No, Your Honor.
All right. Well,
Your Honor,
okay.
Can I get
Yeah.
30 seconds to talk to my client just to verify?
Sure, let's take 5 minutes, okay?
Thank you.
Thank you, Your Honor.
Okay, I think we're up to final arguments. So, Mr. Prestring, would you like to go ahead?
Yes, thank you, Your Honor. Your Honor, we have here a case of breach of contract. We don't have any negligence claims. And in this contract, we've got a partial writing, and we've gotten testimony from the parties admitting that there's a contract for a total amount of time to be $7,150, and then the materials on top of that. Reimbursement for the materials, compensation for the time. So $7,150 is what we're looking at here. What Earth Painting Company and Ms. Goodrich would like to see is for the court to treat this as a negligence claim, which it's not, and to change the terms of the contract. So the contract is very, very simple. That Mr. Silkworth was to do the rooms he was on paper that they agreed on, and Ms. Goodrich was going to do the master bedroom and I think the closet. Mr. Silkworth testified that the parameters here, the guiding principle here, is to not put too much time in because, as Ms. Goodrich said, we're quote unquote putting lipstick on a pig. We want to get this house ready to sell, and that's the main purpose. That was the guiding principle for Mr. Silkworth. That's why he quoted the time the way he did. If Ms. Goodrich wanted something different, she needed to go to Ms. Daniels to get a contract in writing and make Mr. Silkworth a part of that. What Ms. Goodrich did is say, I don't like what you did. I don't like the quality of it. So I'm going to do it to some standard that you don't know about. And then I'm going to tell Ms. Good or Ms. Daniels about this standard. Now, we don't know exactly the communications they had, but again, the bottom line here is that we've got a simple breach of contract action. Mr. Silkworth did what he was contracted to do. He received partial payment for that, and then is due the rest. And so what we're looking for is the time that he's owed, which is $3,150 worth. And the materials is what the parties agreed on, and that's $1,257.77. So Mr. Silkworth is looking for a total of $4,407.77. A few things I do want to point out here is that if I remember correctly, Ms. Goodrich testified that it took her, this was a hearing or two before, took her 2 to 3 days to do the work over that Mr. Silkworth had done that she didn't like. I think she testified today that was now 5 to 6 days worth of time. So I'm not sure how much time she put in, how many days, but I would just direct the court's attention to that, whatever is in the record. I seem to also recall that before it was during the week, and today it's changed to the weekends. So I'm not sure what that was exactly. Ms. Goodrich here was the general contractor. As the general contractor, you're going to take risks. You take risks because you're going to make more of a profit, potentially, but you're going to be on the hook with the homeowner, and that's what happened here. If the homeowner doesn't like the work, then the general contractor is on the hook for it. In this case, Mr. Silkworth expected to come back and to do a walkthrough with the homeowner, was denied that opportunity. He testified that he expected to come back, that he expected to do touch-ups and to do whatever the homeowner wanted. Instead of being given that opportunity to earn the homeowner's satisfaction, Ms. Goodrich said, "No, you're not going to come back. I'm going to do what she said in her text message is an hour of touch-up work." Well, that hour apparently changed into a whole different situation. She wants to hold it against Mr. Silkworth, but she has no legal grounds to do so. One thing I want to point out is she testified, Ms. Goodrich testified that she wanted to fix the trim work, which is a normal part of touch-up. She testified that because Mr. Silkworth didn't caulk and or paint along the trim tight enough, she had to re-roll the walls. Well, that's silly. You don't have to re-roll the walls just because you've got some touch-up work on the trim. I also want to point out that the before and after pictures that we submitted to the court were representative of what the house looked like before. I wouldn't call it a pig. I think it definitely needed some work. And would definitely require more than $7,150 for painters to do that. But that's what the homeowner apparently wanted, and most importantly, that's what the parties agreed on. Because these parties were friends, there were no details in the contract. Ms. Goodrich cannot now enforce details that aren't present in the contract. There has to be a meeting of the minds, and there was no meeting of the minds regarding its additional terms. Ms. Goodrich testified that there was a timeline. You can see it in the text messages. She told John that the timeline was up, deadline was up. In the very brief testimony that we heard from Ms. Daniels, she testified there was no timeline. In fact, she testified the house didn't sell until December, 6 months after the job was done. So there's a little bit of falsehood coming from Ms. Goodrich. Again, if she wanted Mr. Silkworth to do a better job, she should have clarified that. Mr. Silkworth did what he was supposed to, and he satisfied the contract. Thank you, Your Honor.
Okay, thank you, Mr. Pressman. All right, Ms. Schubert, any argument?
Yes, Your Honor, thank you. This has been a really trying experience. What started out as helping a friend has ended up as a third day of trial that should have never left small claims. So within days of defendant mitigating plaintiff's work, he began demanding payment. On July 10th, he filed a complaint in small claims asking for $3,468.88. That was set for a hearing in October, where they went to CRS, and after no agreement was reached, it was set for October. The day after, or the day before, or the morning of the hearing, plaintiff filed an amended small claims complaint with factual errors asking for more money, along with a large number of physical photographs as evidence that weren't shared with defendant. And when the visiting judge conducted the small claims hearing and asked defendant if she wanted him to make a decision based on plaintiff's evidence that she had not seen, she said no, and so the case was sent up to district. After more settlement and mediation attempts that obviously did not result in resolution, plaintiff obtained his first lawyer and filed a motion to amend for a second complaint with different damage calculations, and that was at the end of December. That was set for a hearing, and at that hearing, plaintiff had a second attorney. Both of them showed. Defendant was still in pro per, but both attorneys failed to share any exhibits with defendant. And so at this hearing, defendant was told that she needed to obtain an attorney. She found one. I filed an answer to the second amended complaint as ordered. Several weeks prior to the first day of this trial, I shared all of the proposed exhibits with opposing counsel. But an hour before the hearing was set to begin, plaintiff sent me their proposed exhibits. I objected, and that was overruled. Then plaintiff called a surprise witness that defendant didn't even know. That was also objected to and was overruled. The second day of the trial, plaintiff produced more exhibits that he didn't even share with me until I requested them, and I actually just received all of them this afternoon. And when defendant called the third-party beneficiary to the contract, her testimony wasn't allowed because it was deemed irrelevant. And that's just all the procedural issues I wanted to preserve. So moving on to the legal aspects of the case, this is a breach of contract case, and in cases when there is a partial payment, plaintiff would be owed the amount minus the mitigation costs. So I just want to reiterate that both parties went through the entire house, saw the conditions, drafted the bid with the division of labor and the price. Plaintiff did a little bit of work and then he didn't show up for a couple of weeks. I was bothered by plaintiff's counsel saying that my client said that this was putting lipstick on a pig, because that's not at all what she said. And so when this deadline approached, this is frustrating. Somebody wasn't allowed to testify. So anyways, plaintiff had to scramble to finish everything in a weekend and ended up doing a subpar job. So except for the garage, the chimney, and the garage door, every room had paint where it didn't belong. Every room had old paint showing through, and every room needed wall repairs and caulking. Defendant's witness, Mr. Burns, testified that plaintiff refused to come back and look at defendant's concerns. And so she spent the following week redoing almost all of his work, and that mitigation cost her $2,400. Rolling out a wall is the easy part. Like, the real work is scraping, patching, sanding, cleaning, caulking, taping, cutting, and then you get to rolling. As indicated previously, defendant has been dishonest repeatedly. First, he texted Hannah and said the materials were $1,357.04. Then he said that they totaled $1,549.68. And then he provided receipts that totaled $1,467.57. But these contained duplicates, included a receipt for which he admitted under oath was for a different job, items that should not have been billed to the job, and multiple incomplete and undated receipts that contain only generic materials that could have been for any painting project. Now they're willing to stipulate that plaintiff probably only spent about $1,557.77 in supplies. And that's 4 different numbers. And I mean, I'm not even sure the last one's correct, because some of it is composed of the incomplete and undated receipts. Plaintiff sent defendant a message saying that she owed him $3,468.88. Um, that was multiple messages, which he listed, and that was the same amount that he listed in his first complaint. But then 3 months later, he amended his complaint to increase the amount to $4,699.68. He stated that there were $7,150 in labor costs, plus the $1,549.68 in materials, which we now know is incorrect. And that payment was received in full for $4,000, which doesn't make sense because he testified that he gave part of that to defendant. So this equation obviously has an incorrect total for supplies, and it doesn't take into account any amount given to defendant. So it's safe to say that he's not entitled to that full amount that he's requested in his complaint. Regardless, that whole amount was repeated in the second amended complaint, but with the added variable of defendant receiving $2,250, and that just doesn't add up at all. Plaintiff stated under oath that he was the only one who did the painting work, but his helper, Emily, testified that she did some of the work. And so that just kind of begs the question, which one of them misrepresented to the court under oath? Plaintiff testified that he left all the painting supplies at the work site, first because he was going to come back and do touch-ups, then because he was leaving it for Hannah, but there was additional testimony from a witness who arrived on the site as plaintiff was leaving and saw no supplies whatsoever. And so again, who is misrepresenting? Plaintiff submitted incomplete and undated text messages between the parties that were compiled in a way to lead this court to believe that they were related, when in actuality, the messages were sent and received days and apart in different conversations. Plaintiff also states that he asked for half the job total up front and the rest when the job is done, but then he stated that he gave defendant her full amount in cash, which is, before she even lifted a paintbrush. And it doesn't make any sense that he would do that. And he hasn't been the most honest or consistent in his testimony. Defendant, on the other hand, has been consistent, and based on the weight of the evidence, it seems likely that defendant is telling the truth. She remembers the denominations of the bills and how he bragged about getting the money out of his safe. Plaintiff doesn't remember how much he took out, if he deposited the full amount, and was unable to provide that information. So plaintiff expects you to believe him when he hasn't been consistent in his pleadings. He's been dishonest in his testimony, and he doesn't really remember anything else about the transaction that he thinks he gave her the full amount. And so again, as I stated earlier, this is a breach of contract issue. And when there's been a partial breach, the breaching party is entitled to the full amount of the contract minus any mitigation. I have a spreadsheet that I think would help Your Honor see the math, but I wanted to check with Mr. Prastrink if that would be okay if I shared that.
I would object, Your Honor.
Okay, so the total project bid was $7,150, and the agreed upon amount for materials was $1,257.77. So that brings the total for the job to $8,407.77. There was initial payment to plaintiff for $4,000. And then he paid, out of that $4,000, he paid defendant $1,200, which means he retained $2,800. So if you take the total for the job, $8,407.77, and you take away the amount he retained from the first check, and then you take away the remaining amount owed to defendant, so that's $1,050. And then if you subtract defendant's mitigation, which was 48 hours at $50 an hour, as indicated on our counter complaint, that's a total of $2,400, which means that plaintiff is owed $2,157.77. And I can repeat any of that if you didn't catch it.
Yes, if you would please. So go back to 840777 minus 28, which is the amount he kept from the 4,000. Where did the 1,050 come from?
So defendant's total that she was owed for her portion was 2,250. And so the 1,050 is the remaining after he paid her the 1,200.
Okay, all right.
Yep. And then she had her mitigation of 2,400.
Okay, so what's the total you feel plaintiff is owed?
2,157 and 77 cents.
Okay. All right, so Mr. Prasterink, any rebuttal?
Yes, Your Honor. I just want to mention the lipstick on the pig quote because I think it is important. We've got basically a napkin contract here. The parties put on paper what they were expected to do. Mr. Silkworth did everything that was on that piece of paper on the contract. Ms. Goodrich is asking the court to insert terms into the contract. Legally, as part of the legal framework, we can't do that. And the reason is we don't have an expert witness to testify to the court what standards of painting are or what this contract required. Again, there aren't any terms in there. We don't have a negligence claim. We have a very simple contract. And so what we're asking the court to do is just enforce the terms of the contract. In fact, I would argue that's all the court can do. I'm sure that's probably all the court wants to do. Again, we don't have an expert witness here. That's what's lacking in this legal framework. If Ms. Goodrich wanted to call an expert witness and say, we have this contract that says that the parties have to paint according to the general standards prevailing wherever, and this expert testifies that they did or did not meet those, well, then the court has a standard. Without that, we're left with the terms of the contract. The other issue is that's a slippery slope because if we're looking at mitigation and Mr. Silkworth put in extra time and money in doing things that he didn't need to do, he testified, repairing drywall with drywall mud and spackling and doing extra things. There's one exhibit in there, and I know it's like a hexagon room where he's mudding all of the seams. Well, that's not part of the contract, but that's what he does in addition. So it'd be very difficult, obviously, for the court to do the math and figure out where they are in this quote unquote mitigation process. And so that's why we're asking the court to simply look at the contract. We've got 7150, we've got the materials, we've got what they agreed on, and that's where we're at. The framework that Ms. Goodrich wants simply isn't before the court. Thank you, Your Honor.
So plaintiff is asking for $4,407.77. Is that right?
Correct, Your Honor, which is the benefit of the bargain. That is the contract price.
Right, okay. So it was testified to by Ms. Schubert that she put in work, looks like it was $2,400 for 48 hours at $50 an hour. Hang on just a second. So I'm gonna have to go back to you, Ms. Schubert.
If I could,
Go ahead.
I'm sorry, if I could show that spreadsheet, it could give you like a visual and help.
I think it'd be helpful. So go ahead and put it up, please.
Okay, thank you.
Okay. All right, so that is helpful. So Ms. Schubert, anything else you'd like to add?
I would rebut opposing counsel's assertion that there needed to be like an expert witness to testify about professional standards. We have two professional painting companies suing each other. So they're professionals. And both of them testified that sanding, scraping, caulking, patching, like all of this is part of it. I mean, Mr. Silkworth even said that today. So I don't believe it's unusual to expect a professional job from a professional painting company. And that's all I would say.
May I respond, Your Honor?
Sure, go ahead, please.
I think this is a difficult, obviously, conceptually, at least for me, to understand where we're at here. But what what Ms. Goodrich is asking the court to do is to say the standards that Ms. Daniels had were not met. The problem is those standards were never communicated to Mr. Silkworth. We're here for a contract between Ms. Goodrich and Mr. Silkworth. If Ms. Goodrich doesn't like the standards, then we litigate those. But what she's saying is Ms. Daniels, who denied Mr. Silkworth an opportunity to go on a walkthrough and to do whatever Ms. Daniels wanted. So Mr. Silkworth was denied that. So Hannah said, you cannot go on this walkthrough. Moreover, I'm not even going to tell you what Ms. Daniels doesn't like about the house, about your paint job. And I'm going to go in and do my own mitigation for the stuff that I think should be better. None of these are part of the contract between the parties. Ms. Goodrich has no standing to enforce any of those terms. They're simply not part of the contract.
Okay. Last time you should anything with regard to the owner's standards that apparently Ms. Let's see, Ms. Goodrich, I guess, applied what she thought were the owner's standards. What, do you have a response to that?
I'm sorry, there is a lot of paper shuffling and I didn't catch that in its entirety.
So Mr. Prastering made a good point that if Ms. Goodrich's position was that Ms. Daniels had standards that needed to be met in the painting job, okay, we don't know what those were, if any, okay, and Ms. Goodrich decided on her own to go in and do, I guess, remedial work that she felt were, I don't know, her standards, or we didn't hear from Ms. Daniels, so we don't know what her standards were. So there are really no standards here.
Well, I'm just
testified to any. So what's your response to that?
I'm kind of confused because there literally was like paint where it didn't belong, like on shelves and like the floor and baseboard. Like I guess I'm just a little flabbergasted, like, and confused, because when you hire a professional painting company, I mean, you kind of expect them to apply paint where it's supposed to be. Like, I mean, that's just kind of like a bare minimum. And Mr. Silkworth even testified that all of these prep things that he didn't do are standard. So I don't know why we're arguing about it. Like saying that there's like a different standard that's been like interjected by Ms. Goodrich when, you know, Mr. Silkworth, like, obviously, like, didn't think it was good enough because he wanted to do touch-ups and such. I'm just kind of confused. Like you hire a professional painter to do a professional job, and they testified that includes sanding, caulking, painting, priming, fixing holes, everything. And that wasn't done in this case. So I would argue that it's not like an additional extra standard. It's a professional regular standard, like a standard, not an extra OCD one.
So it's unfortunate that this happened. It sounds like the parties were, before this, friends and work together on painting jobs. Hopefully going forward, maybe they can repair that relationship and continue to work together. But this really was sort of a bad deal, so to speak, right from the beginning. So I think that the fair thing to do under the circumstances, Mr. Prasterink is requesting $4,407.77 to be awarded to Mr. Silkworth. And the testimony on both sides really, I think on balance, people were basically credible. Maybe some things were forgotten. So I think that both sides were fairly credible. So it's really hard to figure out exactly what happened. So I just am working with the numbers, and also the contract really wasn't very good either. So I'm working with the numbers. Give me just a second here. So Mr. Silkworth is requesting $4,407.77 in total. And let me just confirm, Ms. Schubert is, I'm sorry, Ms. Goodrich, pardon me, is requesting $2157.77. Is that right, Ms. Schubert?
That is correct.
All right. So given all the facts and circumstances and the fact that some of the testimony is confusing, I think both sides are making their best efforts to be credible. What I'll do is I'm going to deduct $2157.77 from the $4407.77, which is $2250 to be paid to plaintiff by Ms. Goodrich. Okay. That's what we're going to do. So, can you provide an order then, Mr. Prastring?
I can. What just to clarify, was the court finding a middle ground between the two numbers?
Middle ground between the two numbers?
Cutting the difference between 4407 and 2157.
Yeah.
Okay. I think that math comes out to 3282.77.
Okay. Let me try that again.
And I think I made the mistake the court just did a few times before I got there.
So 4401 minus 2157.
So what I'm doing here is taking 4407.77, subtracting what Ms. Goodrich wants, which is 2157.77, and that difference is 2250. But we need to take that and divide that by 2, and then add that to what Ms. Goodrich has requested, and that puts us right in the middle of where the two parties are.
And that number again is what?
33,282.77.
Okay, so Ms. Schubert, any comments on that amount?
I'm just checking the math. You said 3282.77?
Yes.
So how did you, so JD, like your number is the second payment, right?
I'm just saying that I think the court's
Well, I was just trying to figure out your math, like how you came up
yeah.
with the
So I
4407.
take the difference of the two numbers
No, I mean, no, how did you get your 4407?
Oh, he summed it up. He
Yeah,
summed it
so
up in
you
his
take
closing.
Yeah, 3150 plus the materials that we agreed on of 1257.77.
So what about the part that defendants owed for her part? Because she still
Let me
owed
just,
like the 1,050.
hang on, please. Let me just go back through this. So Mr. Prasterink in his summary indicated 3150 was owed to plaintiff plus the agreed on cost of 1257.77 for a total of 4407. Then Ms. Schubert requested 2157.77 for the defendant, Ms. Goodrich.
Yeah, in other words, what we're doing is, I think what the court is saying is that the amount of remediation or mitigation that Ms. Goodrich is saying, he's just cutting that in two.
Right, so you want the entire second payment plus the materials, but that doesn't take into account the rest that that she's owed just for her portion of it. Because she only got 1,200, and then so she's still owed 1,050 for her part.
That's what you argued. Then 48 hours or $50.
Right, and there's no mitigation in there either in his amount.
I'm
Like
gonna
he just wants the whole thing plus half of what she was owed for her portion.
I'm going to refrain from arguing, Your Honor. I think we're at the position in the ruling where the court was making a ruling, and I don't want to re-argue our position, but I will if the court would like.
But
I think what the court was doing is the same, a mathematical or clerical error that I made several times today already before I corrected it.
So bottom line is what would be the finding is Mr. Silkworth is owed 4407.77. Ms. Goodrich is owed 2157.77 for her remediation. That left 2250 to be paid by Ms. Goodrich to the plaintiff.
right. So how did we get to the 38 or 3282? Because
there was the 20. I've got a lot of notes here. Try to find it again. There's the 2250, I think, that Mr. Prasterink divided. Is that right, Mr. Prasterink? I'm going to ask you to please argue.
Yeah, I will, Your Honor. So what we're arguing is that, and this is only under the contract, if we take the original number of 7150, we subtract the $4,000 that was already paid to the parties. And Mr. Silkworth's testimony was that he gave the full amount to Ms. Goodrich. That left 3150 as the balance in time. The materials was corrected so that we agreed on 1257.77. So he's owed 3150 for the time that he already put in, plus the materials, which gets us to 4407.77. That's what we're asking for.
Right.
If the defendants are asking for 2157, they're asking to be paid for the full mitigation, which we've argued is not in the contract. You can't keep terms out of a contract and then even deny a walkthrough and say, Mr. Silkworth, you cannot do the touch up. I'm going to do it for you. And then I'm going to take that out of what you're owed, which would simply be unfair. You can't have a painter do a job and then say at the end, I'm not going to allow you into the house to tell you what you need to fix. You just can't do that. And then on top of that, you also can't do that and then say, now not only am I going to deny the opportunity to come back, then I'm going to do it how I want to do it and then bill you for it. And so if Ms. Goodrich is awarded, only has to pay him $2250, then she's in a sense being rewarded for all of that. So the only way to make Mr. Silkworth whole is to award him 4407.77. That's the contract price, because Ms. Goodrich had testified that she received from Ms. Daniels not only the original money that was given to her by Mr. Silkworth, but the 3150 that's actually Mr. Silkworth's money. Ms. Daniels gave that to Hannah Goodrich instead. So if she's awarded that, then Mr. Silkworth is literally out of pocket for the job. He paid more materials than he got.
So, Ms. Schubert, are you following that?
I mean, this is assuming that, I mean, my client only received 1,200. So, I mean, not only did she have to, you know, like redo all this work, she's not even getting the full amount that she's owed for her portion of it under the original contract by Mr. Prasterink's math. So
Even-
if you take like the second payment and that 3150, if you take out the 1,050 that she still owed for her portion, that leaves 2,100. And then, you know, she spent 48 hours mitigating it. So she still owed like 300 beyond that 3,150.
And if I may add, Your Honor, even as, you know, I'm going to acknowledge that the court has before it testimony from two people, and it's only testimony. He's saying 2,250, she's saying half that. So they're saying that. So even if the court cuts that in two and says, I'm not sure who's telling the truth, I'm going to cut that number in half, then we would still take 4407.77 and subtract 525 for Mr. Silkworth.
Well, I got an idea. Why don't I put you in a breakout room and you just sell it? Because maybe you just need to do that. Okay?
Okay, thank you, Your Honor.
Thank you.
Yep. It's the attorneys, okay? So here we go.
Okay.
Well, I
Well,
suppose,
do you want our clients to step out?
yeah, please.
Okay. All right, so I'm just gonna talk.
Okay. Yeah, head to the
Wow.
lobby.
So all right, so I'm gonna put Mr. Prastrink and Ms. Schubert in a breakout room. You'll get an invitation in just a second. Here we go.
Did not get the chance to talk to Ms. Schubert again. The notice that you typed on is very difficult to see. So if maybe she saw it.
Sorry, I was muted there. So,
Okay.
well, were you able to talk at all?
Yes, and my client has agreed to the number that I gave to Ms. Schubert.
So what's that number?
It's 3,000.
All right. Ms. Schubert, what is your client's response? Ms. Schubert?
Your Honor, I'm sorry. May we have another couple minutes?
All right. 2 minutes. So do you want to all go back in the breakout room?
I've got my client with me in my office, but I can do whatever the court would like.
I just needed to talk to my client real quick.
Okay. All right.
Thanks.
2 minutes. Thanks.
Okay, thank you, Your Honor. My client's agreeable to 3,000.
Okay. All right. Mr. Prastrink, do you want to prepare the order then?
I'll prepare the judgment, Your Honor, and I'll send it to opposing counsel for a signature.
Okay. All right. We're all set, everybody. Thank you.
Thank you, Your Honor.
Thank you.